Within days of British-registered multinational Ineos signing a £30 million deal to frack from Cheshire to Yorkshire, one shale gas company said it had given up on shale in West Sussex because of pressure from environmentalists. So what more can be done to stop fracking? One mother of two, the founder of Frack-Free 5 Valleys, Jojo Mehta, says it's time to put our MPs on notice. She joins me now via Skype from Gloucestershire. Welcome, Jojo, to Going Underground. I've got your letter here, notice before action, threatening all 657 MPs in Parliament. Tell us a little bit about this letter.
Hi, Ashley. Well, the Infrastructure Act, which has just been passed, was always intended, among other things, to fast-track fracking in the UK, and I found that of grave concern. Now, I came across a report that was put together, here it is right here, by the Concerned Health Professionals of New York, and it's a compendium listing and detailing the risks and harms from fracking, and it's based on lots of studies over the last few years, and it was instrumental in having the state of New York ban the practice of fracking. Now, I thought, how do I get this in front of every MP? I know that MPs, when they vote on issues, don't always have the background information or the time to look at it. So how was I going to do this? And I consulted with a lawyer friend and came up with this notice before action. Now, MPs in the UK have a code of conduct that says that they have a duty to act in the interests of the nation as a whole.
That's right, in the second paragraph, isn't it? You draw their attention to this report, and then you say that what you're doing could breach the code of conduct of the members of Parliament.
Exactly. So they have a duty to act in the interests of the nation as a whole. Now, what is the national interest? What can it be other than the health and well-being of the land and the people that live here? Nothing else makes much sense to me. And certainly, a duty described like that in a civil court would be upholdable. It would carry weight, and it's a kind of a duty of care. Now, essentially what that means is that if the MPs know in advance that fracking can bring risks and harm to the UK, and they knowingly go ahead and vote for that, then they could, if harm arises, be held liable, because they are essentially in breach of that duty of care. And so that was the reasoning behind my letter.
In fairness to MPs, on the 12th of February, the infrastructure bill quietly got royal assent, and that does say there's a legal duty to maximise the use of resources. Tell us about the infrastructure bill and why it's so important.
Well, in fact...
Act, I should say now.
It is now an act. It was rushed through with really unseemly haste. I mean, when I sent my notice before action, it was still at the committee stage. And interestingly, there was a little flurry of amendments that followed my letter. Now, obviously, I'm not trying to claim all the credit for that, but it may have had something to do with it, because there may have been some MPs who went to their lawyers and said, well, hold on, can you tell me, should I be worried? And the lawyers might well have said, well, actually, she's got a point. And there was a flurry of amendments. And in fact, there were amendments put through that would have controlled fracking quite a bit, would have made it impossible to frack under areas of national beauty, for example, sites of special scientific interest, national parks, and so on. And then when this went back to the Lords, there was a whole sort of slew of watering down kind of amendments that were then amended to that amendment, put in place of it. And this was done very, very fast, and it was very slick. They must have had some good lawyers on that. And it went back to the House of Commons, where it was only allowed 1 hour's discussion, which is appalling, really. And Caroline Lucas, the Green MP, was actually the only person to really notice that what the Lords had slipped in there was a definition of the kind of fracking that would be subject to any safeguards at all. And it meant that only fracking that involved cubic meterage of liquid, more than 1,000 cubic meters, would actually fall under those safeguards. So any frack below that amount of liquid is actually not subject to any kind of special permission at all.
And as you say, since the letter, there have been moratoriums announced, mitigating clauses. Fracking, though, will be allowed to, companies will still be allowed to drill horizontally under national parks.
They will indeed.
This.
They'll actually be allowed to do it pretty much anywhere, so long as they keep below this particular limit of liquid. And actually, as far as we know, any fracking that has gone on so far in this country has been below that limit. So in fact, it's a bit of a carte blanche with a kind of disguise of, oh, we're putting some safeguards on, but those safeguards actually only apply above a certain volume of liquid. And so there's a huge get-out clause, which will be why, Lord Brown, etc., will be saying, well, yes, we will be going ahead and fracking.
What do you think about what the Environment Minister, who also will have received your letter, said when Amber Rudd said that guarantees to drill in dangerous areas, they're just not practical if they unduly constrain the fracking industry?
Well, why are we not trying to constrain the fracking industry? The evidence of the risks and harms is out there. The political will should not be going to dirty practices like fracking. It should be going to renewables. We should be looking to the forms of energy that are not going to damage our planet and that are not going to damage our people. Essentially, this government has a hugely pro-fracking stance. One of their big reports was called "Are We Fit to Frack?" It wasn't called "Is fracking a good idea?" It was called "Are we fit to frack?" The assumption is that fracking is a great idea and we need to check whether we're up to it. I think that's completely unacceptable.
And what next if fracking does go ahead in an area where you and your lawyers happen to be looking at?
It actually, the beauty of what I did is that it actually doesn't matter who sues their MP, because they've all been notified. And the point is, the principal point of what I did is that none of them can claim that they did not have prior knowledge of the risks and harms, because I provided that prior knowledge to all of them.
Thank you.
Thanks, Ashton.